So I have an important update on the ATF's restrictions on forced reset triggers. You may recall that recently it was struck down completely with a final merits decision, but now the ATF has asked for an appeal. They've also asked for a stay of that decision, which is going to impact a lot of people. So we need to break down what is happening. Now, really quick before we jump in this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you want to support the channel, that's a free way to do it. Of course, you're not obligated by any means. And then also just double check to make sure you're still subscribed, because YouTube loves to unsubscribe people. Now, as I mentioned in the intro, in this video, we have some major news in the battle against the ATF and the restrictions on forced reset triggers. You may recall that earlier this year, we received news that the lower court here, Judge Rita O'Connor, issued a preliminary injunction which blocked the ATF's current attacks on forced reset triggers. And then now that very same judge, just a couple weeks ago, the great and powerful Judge Rita O'Connor, granted NAGR, the organization here, and then also Rare Breed Triggers, their motion for summary judgment. Now, in legalese, that is just a motion essentially to end the case early. And ultimately, Judge O'Connor ended the case early in favor of the plaintiffs here, the organization here, NAGR, Rare Breed Triggers, the company, and then also a bunch of other individuals as well. That means that the ATF's FRT restrictions were found invalid. They were found a violation of the APA, and they were struck down in their entirety. But now the ATF has filed a new notice to the court here, to Judge O'Connor, asking for a few things. First, they are notifying Judge O'Connor that they are, of course, going to appeal that decision. But also they're asking for Judge O'Connor himself to grant a stay on his own decision. And they're asking for a stay so that they can go and appeal to the Fifth Circuit. And if granted, it's going to impact anyone involved with this whole FRT issue, or anyone who maybe has these items or wants to acquire these items. Now, to understand what is going on in this case, I need to lay some groundwork so that you understand what's been going on with the multi-year saga between the ATF and then also the company here, and then other individuals who are in possession of FRTs. So back in July of 2021, the ATF sent out a cease and desist letter to Rare Breed Triggers and then other companies. The letter of the ATF essentially claimed that in their eyes, the Rare Breed FRT-15, which is a forced reset trigger, essentially it meets the NFA and GCA's definition of a machine gun. And because of that, the ATF claimed that the trigger itself was subject to registration, taxation, and possession restrictions, just like an actual machine gun, very similar to what they did with bump stocks. Rare Breed then partnered with the National Association for Gun Rights and filed a lawsuit against the ATF in the Northern District of Texas, and the case was assigned to Judge Rita O'Connor, who was responsible for a lot of wins coming out of ATF cases, since Judge O'Connor was already reviewing some of the pistol brace cases, the unfinished frames and receiver Vanderstock case. He was assigned this lawsuit as well. Now, while all this was going on, there was a different lawsuit which was filed by the United States government against Rare Breed Triggers, and that happened in the Eastern District of New York. Ultimately, the federal district court there in New York ruled in favor of the federal government, the US government, and granted their preliminary injunction against the company Rare Breed Triggers. Now, the New York lawsuit is very important because Judge O'Connor also had some carve-outs in his recent granting of the motion for summary judgment. There were some carve-outs specifically because he can't impact what is going on there in the New York lawsuit. So he had some carve-outs, and that's also very important for some of the things that now the ATF is asking for on appeal. Now, like I mentioned, while that New York lawsuit was going on, the plaintiffs here also filed their lawsuit in Texas. Now, on review, originally Judge O'Connor granted the plaintiffs their preliminary injunction. So for a long time, there has been a limited preliminary injunction in place, which is protecting NAGR, some of their members, and then other individuals who are named plaintiffs in this lawsuit. Now, after the preliminary injunction, which you guys know is kind of this middle ground in between lawsuit, the ATF also asked for a stay of the preliminary injunction from Judge O'Connor and then also from the Fifth Circuit. Both were denied, and now this lawsuit is moving forward at the Fifth Circuit level. So that's with the preliminary injunction. So you can see there are kind of two stages of the very same case. Right now, there's an appeal of the preliminary injunction, but while that's still pending up there, there was down here in this lower court area, still in front of Judge O'Connor, it was moving towards a final merit decision on a motion for summary judgment. And that was recently granted by Judge O'Connor. He struck down the entire rule as invalid, violation of the APA, all of that. And now the question is, what is going to happen? The ATF has filed notice to Judge O'Connor saying that they are going to appeal that also up to the Fifth Circuit. So then you're going to have two lawsuits kind of in the same lawsuit with two different decisions from the court sitting at the same level. Now, in the interim, also what the ATF is asking for is a stay on what just happened. Now, also in this request, they are saying at the very least, Judge O'Connor should issue a stay on the 30-day return of the devices notice that Judge O'Connor included in his recent decision. You may recall when we talked about this last time, in that decision from Judge O'Connor, he said that the ATF had 30 days to essentially notify all individuals who had their items confiscated that there is a new decision, that the ATF's rule is invalid, and they had 30 days to return all of those devices. The ATF here is saying that Judge O'Connor should at least put a stay on that, so the 30-day requirement should be removed. And the main argument for the ATF on why this should be stayed, at least that 30-day notice, is they say there is no way we can actually return all those items in 30 days. We could confiscate them in 30 days. They were clearly able to confiscate them very fast and then prosecute people very fast. But they're saying, hey, there's no way we can return all these items. We don't know who actually should have these items. So we can't do it in 30 days. We're going to appeal this, and you should just put a stay on this. They also say that returning some of these items in certain states to certain members and individuals would potentially violate state laws about machine guns. Now, so they're saying, hey, we can't return some of these triggers because we are still claiming they're machine guns. Some states still claim that they're machine guns, and we can't return them to certain individuals, maybe in like California, New York, New Jersey, because it would violate state law. Now, that's also very interesting to say to a judge who just looked at the statutory language and found that these are clearly not machine guns, that they don't meet the definition, but then to make the same argument of, hey, we can't return these to certain states because they're machine guns. Now, one of the other things that they include in this request is they say that there should also be a halt on them having to send out notices or letters to various individuals and plaintiffs at large, because they argue sending out the notices to individuals could cause a lot of legal confusion because maybe they sent out a letter saying, hey, we were wrong, our rule was struck down. This court here in the lower court in Texas said that our rule is invalid. They send out that notice to everybody, and then they say, well, we're going to appeal this anyways, and it could cause confusion if something goes in our favor, which, again, I don't think is going to happen because this is in the Fifth Circuit. The Fifth Circuit panel that's already reviewing their preliminary injunction has denied a stay before on the preliminary injunction. So I don't think really anything's going to change for them anytime soon. But here they're arguing this whole legal confusion that they don't want to confuse people, and therefore this ruling should just be stayed outright. In their request, they state that at a minimum, the court should stay its order requiring return of devices to defendants' possession, except insofar as it requires defendants to return devices to members of the plaintiff organizations who request their devices and provide sufficient documentation to demonstrate their membership and coverage by the court's order. So that's also very interesting. So they're saying, yes, we want this broad-reaching stay, but if you don't want to give us this broad-reaching block of your decision, at a minimum, we should say that everything else is going to be blocked except for if there's a member of NAGR or maybe a customer of one of these companies. If they come to us and show and provide proof that they're a member of the organization or a customer, well, then we'll return their item. But who's really going to step up and go to the ATF, provide membership, you say like, yes, I have this item, or I had this item, I want it back, or whatever. Who's going to do that? Who's going to reach out directly to the ATF, and the ATF knows that? So this is some very interesting developments in this lawsuit. We knew that the ATF is going to appeal up to the Fifth Circuit. What I think is likely going to happen is I do think that Judge O'Connor is going to remove the 30-day return requirement of the ATF. I think he's going to find that if there's going to be an appeal, maybe that shouldn't happen. So I could see him putting a stay on the 30-day notice in return of the devices from the ATF. But I don't think he's going to do anything else. I think he's still going to leave everything else in place. You know, you still have the preliminary injunction in place, which technically is still protecting members of NAGR and customers. And so nothing has really changed as far as that. So, you know, they were not willing to stay the preliminary injunction. I don't think that they're going to be willing to stay broadly the final decision. And where that's going to leave everybody is, yes, there probably is going to be an appeal up to the Fifth Circuit. The smaller preliminary injunction one that's over here, that's going to go away. The final merits one over here is going to proceed forward, and that's going to be the big one. But while that's all happening, members of NHGR will still be protected. So I think it's going to be very interesting to see how this develops going forward, because there's a nuanced variety of things that are being asked for on this stay request. I will let you guys know if anything else changes, because again, that's going to impact a lot of people depending on what happens with this stay request. So if anything else changes, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.